Let's bring you some more reaction now to that Constitutional Court ruling that the former president is guilty of contempt of court. I'm now joined by Dubazana attorney's legal expert Nthabiseng Dubazana, Helen Suzman Foundation's legal counsellor Anton van Dalsen, the former public protector Thuli Madonsela, and political analyst Sipho Seepe. I'm just surrounded by these professors all around this hour. Can I begin with you, Prof. Madonsela? When you heard the news of the Constitutional Court ruling in this particular matter, what were your first thoughts? How did you react initially to this news?
Good afternoon, Dan, and to the viewers, as well as to the colleagues. My immediate reaction to the judgment was twofold. I was sad that it had come to this, because I thought there could have been a better way, a way where the president of our country, who was the one who established the Commission of Inquiry, should have been the first person to respect the Commission and to respect the rule of law. But at the same time, the judgment gave me a lot of hope about the rule of law in this country. It reminded me when President Nelson Mandela said, even the most benevolent of governments have within them people with propensities for human failings. And that's why we have these structures that have to make sure that when people have been disappointed by those in government, there are courts and other structures that can make things right. And therefore today, any Gogodlamini anywhere in this country must have their hopes restored, that it doesn't matter who you are. The courts don't look at your name. They just look at, did you act in accordance with the law? And if you didn't, they do what's right.
Professor Seepe, from a political analysis perspective, what was your initial reaction when you look at the politics of it all? I'm asking this against the background that says President Zuma, in how he has dealt with this matter over the last few months, including his refusal to go to court and argue against this order and why he should not be held in contempt of court, he saw it as a political agenda, that he's being attacked from a political perspective, that the judiciary was also playing a political game.
Yeah, I think we must also look at this case in totality, not only in terms of what is presented as clinical case of not wanting to appear before the commission. There were issues to be raised, and where I agree with Professor Madonsela is that it's unfortunate that it had to come this way. We are a country that has a history of always finding a way around what appears to be a precipice. But at the same time, we are also a country of laws, and there is a rule of law. But there's also a rule of law, but there's also justice. Here you have a case which the Constitutional Court seems to acknowledge that there was a recusal that was being put for Judge Zondo to recuse himself because President Zuma felt that the justice will not be served. So it's something that even as we speak, we cannot ignore it because that case has been filed. But where I agree is that this is unfortunate. But what is also important is it is not only about the rule of law, it is also about a sense of justice. Is justice being served? Do people think that you talk about justice must be done, but must also be seen to be done, and it must also enjoy the support of the majority? But if there is a sense that maybe we may not have handled this, it does not. We can be satisfied that somebody has gone to jail, but it does not resolve the issue of a sense of injustice. And I think sometimes the courts and the judges must err on the side of caution and still say, is there another way in which we can hear this important version or statement? Effectively right now, at the end of it, we are all losers because some of us were interested in also hearing the testimony. And here was a former president saying I cannot testify before this person, and none of us can deny the fact that there is a relationship, there is an issue of quarrel. This is why somebody who's as qualified as Advocate Sikakane even said he is going to take Zondo, the judge, to a judicial service.
Prof,
so
yeah, he was given the opportunity to go, but on those bases he said he didn't want to go. But even with the Constitutional Court focusing on this matter of not following the order to go and give his side of the story, and then he was held in contempt of court. But he was given that opportunity to go. But now, the other matter is Helen Suzman Foundation. You were part of this. Anton. Were you part of the applicants here in this case? What's your initial reaction? How did you react when you heard the ruling?
Well, we were acting in the case as an amicus curiae, and the essential argument that we put to the court was that they should also consider a suspended sentence, not just pure punishment as the Commission asked for, a suspended sentence on condition that Mr. Zuma does actually testify. So that was the argument that we put before the court. But as far as the judgment is concerned, I think there are a couple of very important things. One is it's an extremely strongly worded judgment, much more strongly worded than you would normally expect from a court judgment. And it wasn't just on the case of the contempt of court in the specific case that the court was so used such strong words. It also addressed what it saw as a widespread attack on the judiciary in general by Mr. Zuma. And I think one must not just focus on the contempt of court, but one must also focus on this other aspect as well.
So very strongly worded, and Nthabiseng, I don't know if you've had time. I know you were in court earlier, handling another matter at the Palm Ridge Magistrate Court, but you've graciously accepted to be here now. What stands out from you? I mean, as an attorney, when you had the tone was strong, and as Anton's saying, they used this ruling to address a number of things around the rule of law in the country, not just this matter of contempt of court. As a lawyer, as a practicing attorney, how did you react when you heard this ruling?
I feel that what ought to have happened in order to avoid to get where we are now is that there should have been fighting that was done on the side of Dr. Zuma. From where I stand, when I heard the ruling, when I was sitting in court, I was of the opinion that, well, firstly, the contempt was a given. He would probably be found guilty of contempt of court, or rather contempt of court for failure to adhere to the Constitutional Court order to appear. But when I heard the sentence, that's where the shocker was. As my colleague just mentioned from the Helen Suzman Foundation, a suspended sentence is something that you almost expect to go hand in hand with a contempt of court ruling or finding. So when we heard that it was strictly or straight 15 months imprisonment with no option of a fine, no option of suspended sentence or anything of the sort, and then you look at the Commissions Act itself, where it says that as a witness who fails to come and testify, it should be imprisoned for no more than 6 months imprisonment. You start to wonder, were we taking over? Did the court take over the rule of law a little bit too far, or was he now being sentenced for other matters outside of the issue of the contempt of court? Because when you look at the actual act and the sentence that is prescribed in the Commissions Act, it's no more than 6 months. So how did we get up to the 15 months?
Remember, the Zondo Commission in its submission, in its application rather, had asked for 2 years and all of that. Maybe that there was a balance of that 2 year that was requested by the Commission and other factors, because the acting Chief Justice, Judge Sisi Khampempe, was at pains to really go all the way. It came across to me like the Constitutional Court was saying, we've been here before with different issues around the former president. We are now tired. We must just address this and send a very strong message. Is that a sense you were getting, Prof. Madonsela?
No, not exactly that. I do think that the court was not being vindictive towards President Zuma. The court applied the law in as impartial as possible a way. At the end of the day, I think the judgment was meant to serve two things. One was to get President Zuma as a person to take the law seriously, to understand that much as he have grievances, none of us have the right to choose a judge. He was lucky that he had an opportunity to choose a judge, in that although the terms of the public protector said only the Chief Justice should select, but by virtue of his own executive authority, he had the power to say, not this one. And we get from the discussion between him and the Chief Justice that something must have happened, because on the one day the Chief Justice submitted one name, and on the other day the Chief Justice submitted a different name. And President Zuma always knew that he had a relationship with the Deputy Chief Justice. So he didn't just suddenly discover now in 2021 that there was that relationship, and therefore I don't buy the idea of an apprehension of bias. I really don't.
Okay.
And I don't also think that the court wanted to specifically act against him because he had annoyed the court. I think the court just wanted to make sure that we uphold the rule of law in this country so that everyone learns that the courts are there to make sure that we don't all take the law into our own hands.
Yeah, I mean, there were a couple of expressions in that ruling about making sure that we all understand that nobody, including a former head of state, is above the law. Let me just say at this hour, before I get more comment, that we're expecting, as we speak, a media briefing by the governing party, the African National Congress, the ANC, earlier letting the media know that they will look at the judgment and then they will pronounce on their reaction to it. So as soon as that starts, I might have to leave this discussion and take our viewers live there. We are waiting for that ANC briefing. Prof. Seepe, I saw you shaking your head there as Prof. Madonsela was expressing those views there, but she is correct. President Zuma chose the Deputy Chief Justice to be the chair of this commission.
Yeah, actually, I think there is an issue of where he was directed through the Chief Justice. I mean, I think Professor Madonsela remembers her own report. But let's shift away from there. The most important thing is that we want to hear the testimony. We are going to be deprived of that submission. And secondly, you might be correct to say, as my colleagues are also suggesting, that there could be a sense of irritation by the Constitutional Court. But it is not what we expect the judges to do. The fact that you are irritated should not influence. And Professor Madonsela is the only one who seems to suggest that that thing may not have arisen. So but we cannot move away from the fact that inasmuch as he may have chosen, let's agree on that, but there was a quarrel between the Deputy Chief Justice and Skakane on a matter that said, I will take this matter for review. So there's an issue of a review that you cannot ignore in law. There's also an issue where Skakane was saying that your behavior also undermines a situation where we can talk about whether you are a referee.
Yeah, but Professor Seepe, let me just come in here. That happened, yes, and then after that whole thing, or the walkout happened, then the commission applied to the Constitutional Court to say, we need the former president back here because the country deserves to hear his testimony.
Here's the issue. Yeah, here's the issue. No, what he did, he simply left it to the Constitutional Court with the understanding that the Constitutional Court is aware that there is a review application. So he was simply saying, I'm leaving it to the court to make a decision. So it doesn't matter. As my colleagues are saying, when it comes to contempt of court, it was very clear that that would have been something that would have been found. I don't think there is a debate about the contempt of court. But at the same time, given all these other issues, the issue that we must also say as South Africans is that is justice being served. It cannot be simply the rule of law. The rule of law must also go with justice. Okay. And this is where the Helen Suzman Foundation was saying, it makes sense also to come up with a suspended sentence. And also, our colleague was also suggesting that, because what we want to do, we want to hear the testimony.
Yeah, okay.
Very important.
I get the point. I get the point. Anton, are you disappointed the sentence was not a suspended one, taking into consideration what we're hearing in the last few minutes?
I don't think so. I understand the majority judgment. I listened to it in full this morning. I understand and I respect it. The submissions we made to court were done in the, we weren't an active party in the litigation. We were a friend of the court, and we thought that the court would find it useful to have alternative remedies put before it to consider. But it decided against it, and I completely understand the way that the court went in the end.
Yeah, Nthabiseng, I mean, do you understand it as well? I mean, as an attorney, that the court had to go this way?
Well, I'm not sure if I understand it, but I accept it. It is the way that it happened, and the court was of the opinion that there is no other or alternative way of sentencing the accused in this matter. Because in practice, what would usually happen in a normal criminal court setting would be a situation of the accused is then asked in an inquiry setting why he failed to appear before the court, give his reasons thereof, and if the court is satisfied with his explanation, then the court will then do away with the warrant of arrest that would have been issued when he was not appearing. But in this instance, Jacob Zuma failed to give his side of the story as to why he failed to appear before the commission. I would assume, like one of my colleagues has just said, that left in the hands of the court, knowing or assuming that they are aware that there is a pending High Court matter pertaining to the request or the application that the Deputy Chief Justice must recuse himself, hoping that they would take it on the other route, saying that let us wait for the outcome of the pending matter before we make a decision based on the failure to appear before the commission. But I don't know how that, the precedent has been set, so we will see how it works out in the future. But for now, it is an issue of
yeah, it hasn't happened before that a former head of state has been imprisoned in democratic South Africa. This is a first for everybody, and the words have been used that it's a legal precedent. And I mean, Professor Seepe talking about justice, serving justice, and when you look at the summary of the judgment, it talks about rule of law, judicial integrity, vindicating the honor of the courts. I mean, those are the words being used in the ruling of the summary. So it was really about that. And we have no debate here about the contempt of court. As Professor Seepe said, we knew it's going to come. Whether the sentence is suspended or not, that's something else. But the court felt there had to be appropriate action as well. I've just been told that the ANC media briefing, by the way, on this matter is about to begin. I'm hoping you can stay on. You can be able to listen in as well as soon as it begins. We are just getting the technical things sorted out. So